So many responsibilities. All right, Ms. Love, you can tell victim witness folks it is live. And why don't we get started? So this is case 10SC 92615. It was meant to be a status conference. So I will tell you, there is not a court reporter here. We're not making an official record. I didn't know Mr. Lowe would be joining us, but it is great to see him, and it means we can be a little more substantive in our discussion. But if anyone was thinking that a formal record was being made, there's not. I think the way this YouTube feed works is that this will be archived for a little bit, but I wasn't planning on there being a transcript of today's proceedings. I may enter an order based on what we talk about, and if people want time to file other pleadings, we can do that. But let me first figure out who all is on the call, so we understand the stakeholders who are here, and then I'll explain where I think we are procedurally, and then I very much want to hear from both the state and Mr. Lowe's counsel about what's going on. So I'm Judge McBurney, Mr. Lowe. I don't know that we've met before, but I've inherited your case. Judge Downs worked on your case for many years. And her caseload eventually ended up with me. So I'm the judge responsible for your two cases, and we're going to talk a little bit about them today. So that's who I am. Ms. DeRue.
Good morning.
Good morning.
I'm the forensic director at Georgia Regional Hospital, Atlanta. I evaluated Mr. Lowe in 2018, 2019, and 2020.
18, 19, and 20?
Yeah, 18 was an annual civil commitment, and then 19 and 20 were.
Okay. Thank you. And you're at Georgia Regional?
Correct.
Okay, great. We know who Mr. Cook is. We know Ms. Nelson. Dr. Chan.
Good morning.
Good morning.
I'm a forensic inpatient psychologist at Georgia Regional Hospital at Atlanta. I was involved in the July 26, 2021 competency evaluation.
Got it. Thank you for being here. Oh, people are bouncing around. Mike, sure. Okay, Dr. Subramani.
Yes, I'm Dr. Olivia Subramani. I'm a postdoctoral fellow in forensic psychology with Emory School of Medicine. And I was completing a 4-month rotation at Georgia Regional Hospital, Atlanta, and was involved in the July 26, 2021 evaluation, competency to stand trial evaluation with Mr. Lowe.
Great. So you and Dr. Chan worked together on that?
Correct. She is my supervisor on the case.
Got it. Okay. She a nice supervisor?
Very nice.
Good to hear. All right, not to put you on the spot. And it may be Dr. Shao. You're wearing a white jacket, so I'm going to assume it's Dr. Shao.
Yeah, it's pronounced perfectly.
All right.
And I'm a forensic psychiatrist at Georgia Regional Hospital, and I completed the evaluation in June with Dr. Chan and Dr. Subramani.
This is what we've been calling the July 21 evaluation?
The June evaluation.
Okay, but of this year, 2021.
Exactly.
Okay, great. Well, thank you for being here as well. Ms. Love, you're on separately, which is fine. And then there's an L.E. Richards. I don't know L.E. Richards. It's great that L.E. Richards is on. Is this another doctor?
It's his assistant orderly.
Oh, that's Mr. Lowe, right?
Mr.
Okay,
Lowe.
great. Okay. So thank you everyone for being here. I know you've got other things going on, but this is an important time for us to reconnect. It's my first connection to this case. This is a case that was indicted in 2010, so 11 years ago. And I know that Mr. Lowe has been struggling with some mental health issues and trying to achieve some stability in his life. And he was, I believe, civilly committed by Judge Downs. What brings us together is the report from Dr. Shao, Chan, and Subramani indicating that in their expert opinion, Mr. Lowe is in fact competent to stand trial and to move forward with these proceedings. To be clear, there's a second case, an even older case. The charges are less serious. And so my plan would be for us to focus on the 10 SC case and not worry about the 8 SC case until we sort out what's happening with the 10 SC case, which involves a charge of murder. So it's as serious as it can get. Ms. Love filed something that got to me via email at about 4 a.m. this morning. Not that I was awake. I feel bad for Ms. Love. I was fast asleep. But when I got to work, there was the motion that I think sets out where we are because of the finding, if I'm understanding it correctly, from our colleagues at Georgia Regional. We're at a crossroads again where either I'm assuming Mr. Lowe could do it again. He could challenge the competency finding by way of a bench trial in front of me or a jury trial in front of jurors to discuss the issue or for them to weigh in on the issue of competency. Or Mr. Lowe could say through counsel, and it doesn't have to happen today, it's going to need to happen soon. You know what? There's been some amazing work done at Georgia Regional, and we, the lawyers who work on behalf of Mr. Lowe, conclude he can assist us. He does understand the nature of the charges, et cetera, and we need to move forward. It's 11 years old, and it's time for the case to be resolved by way of negotiations or a different type of jury sitting in here deciding guilt or innocence. So I think that's where we are. And Ms. Love has flagged that really time is of the essence because of this finding that Mr. Lowe is in a stable and competent state. We don't want to miss an opportunity to perhaps get closure. And whatever we decide, I certainly want to get guidance from everyone about how to work with Mr. Lowe, because I have experienced, as I believe at least 2 of the lawyers here have experienced in a different case, we move a defendant, he leaves an environment where he has obtained stability, and he enters an environment where he loses that stability. And we have to reset some things. And that doesn't help anyone. It frustrates the process of resolving these serious charges, which need to be resolved if they can. So with that, Ms. Love, anything more you want to share with me and with counsel for Mr. Lowe beyond what you put? I mean, have you all, Ms. Primovic, are you the lead spokesperson? Ms. Shubo, how are we handling it for today?
Ms. Shubo will be the lead for all the competency mental health.
Okay.
She'll be the lead when we get to trial.
Got it.
We get to trial.
That's a fair division of labor. Ms. Shubo, did you get a chance to see what Ms. Love filed?
I got it pretty much at 10 minutes before the court started, so I skimmed it, but I haven't looked at it in detail.
Okay, well, I think we're in a similar situation, but the gist of it, I think is sort of what I described. And
yes,
it's nothing earth shattering other than saying, hey, we need to figure out which way, and the state is pressing, understandably, to move forward in some direction. Ms. Love, what do you want to add to what I've already described as to where we are?
Your Honor, that as the court's already noted, that we've got the DBHDD psychiatrists and psychologists on the line, and I would ask that the court hear from them to inform the court's decisions about which way to go next. I will, of course, let defense counsel speak for themselves. We had a short conversation prior to the court coming, Your Honor, coming to the bench. But our position is that at this point, because of where we are, we need to know just what he intends to do, and to delay the proceedings that would normally follow this finding by DBHDD beyond the point of the 45 days after the court is notified of that finding, would be contrary to the statute, and actually might even be contrary to what's best in this case for the defendant, and for his stability and for our ability to get closure overall. So we would just reiterate that this motion is just simply intended to set some definites so that we can operate within those parameters.
Got it. I'll certainly hear from the doctors, although again, today wasn't meant to be a hearing where I'm persuaded one way or the other. It's more of a status, but I'll certainly want to confirm from Dr. Chan or Dr. Shao that my understanding of their findings is in fact what their findings were. Ms. Shubo, tell me where you think we are procedurally. And I want to be clear, I'm not expecting you or Ms. Bernadette to say today, here's our plan.
Right.
But I am expecting us to set a pretty tight set of deadlines so that you and Ms. Primovic have a chance to meet with Mr. Lowe, whatever that would mean, virtually or in person. But time is of the essence, it sounds like to me, based on the July or June report from DBHDD. So I want us to seize this moment and move forward. So with that, tell me where you think we are procedurally.
So Ms. Primovic, myself, and Ms. Walsh went to see Mr. Lowe on Friday in person at Georgia Regional. We had about an hour and a half, 2-hour conversation with him, 2-hour conversation. After that, our very lay lawyer, not doctor opinion is that we don't believe he's competent. So yesterday I had about an hour and a half long conversation with Matt Norman, with Dr. Norman. Dr. Norman evaluated Mr. Lowe in 2011 and again in 2016. I think because he already has that kind of history, he would be appropriate to reevaluate him as well. We spoke to him and he needs between 45 and 60 days. I have a contact order already written up for Your Honor that also we're going to need all the medical records from 2011 to present. I think Dr. Norman has up till 2016, so I can maybe narrow that with Georgia Regional. I definitely think that depending on the outcome of that evaluation, if Dr. Norman agrees with everyone, then we can possibly move forward to a trial. I assume, though I don't know, it's going to be an NGRI trial. If Dr. Norman disagrees with the evaluation, then I think we'll need a competency trial. Our guess, though again, we'd have to have a conversation, is we would like a bench trial on that.
Okay.
So that's kind of where we are.
So I won't call it timeline yet because we'll hang some deadlines on it, but the process you see is Dr. Norman spend some time with Mr. Lowe again to opine. If he concurs with Drs. Chan, Shao, and Subramani, then it's trial time, if the case isn't otherwise resolved.
Correct.
As to guilt, innocence, and it may be NGRI, but it's a trial on the merits of the case.
Yes, if everyone agrees, if all the doctors agree that he's competent, again, lawyers, not doctors.
Right.
If the doctors all agree, then there's not much else to do.
Good.
If the doctors don't agree,
Then we have the battle of the experts.
then we have the battle of the experts.
And your forecast, but not commitment, is that would be a bench trial.
Our
The
forecast
battle
would
of the
not-
experts.
A battle of the experts would be a bench trial.
Okay.
Yes.
Got it.
But again,
and-
forecast only.
Understood. And then if the ruling that flowed from whatever format the competency trial took was that, in fact, Mr. Lowe is competent, then we would move forward as if Dr. Norman had said, I agree with the Georgia Regional doctors.
Correct.
Okay. All right. I think
And we might need some time in between the two because Dr. Norman cannot do an NGRI criminal responsibility evaluation till someone says he's competent, because you have to ask questions that would violate that. He has to be able to waive his rights to answer the questions.
Sure.
So we couldn't do it back to back.
Okay. No, it would be necessarily a tiered process.
Tiered process.
And the first gate we clear is, what does Dr. Norman think about Mr. Lowe's competency?
Correct.
Okay.
And just informally, since, especially because he's already been previously declared not only incompetent, but not restorable, we're definitely in that realm of, we're worried about that. And also based on the conversations we've had with Mr. Lowe, we're not feeling confident that he is competent.
Understood. That's why you're bringing this up. So I guess you all tell me which doctor I should start with. I'm assuming Dr. Chan as supervisor of Dr. Subramani. I don't need to hear from all of you. I just want to make sure that I have properly absorbed and understood the meaning, the import of the findings that you all made from your assessment of Mr. Lowe this summer 2021. As I understood it, it was your expert and learned opinion that Mr. Lowe was competent to stand trial. Is that a fair distillation? The report was very long and very thorough, but I always turn to the very end and see what you guys write. Then I go back and read through all the materials you considered, et cetera. But was that the gist of the report, Dr. Chan?
That's correct. And for the sake of Mr. Lowe's case, I think Dr. Shao, who is a forensic psychiatrist, would be better to kind of explain about his situation to the court for today, for this, for the status hearing. So I will let Dr. Shao go ahead first.
So Dr. Shao, if you want to just give a brief synopsis of what it was you concluded and why, that would be helpful. And then we'll take it from there.
Yeah, it was actually all three of our conclusion. Dr. DeRose as well. For the past 3 years, Mr. Lowe has been competent to stand trial and he remains stable. That's why Dr. DeRose is here. She had conducted the past 2 evaluations, 2019, 2020. Again, 2021, we concur with that decision. In fact, Mr. Lowe has remained quite stable for the past 3 years. Dr. Chan pointed to me as a psychiatrist because if you did have questions about medications and how he's able to be stable, but previous found incompetent, not restorable, I can explain that via the medication changes.
Okay. Dr. DeRoe, I'm curious procedurally if the court dropped the ball, and you can say yes because it wasn't me, so I won't get upset. But it sounds like now for 3 years running, someone at Georgia Regional has been saying, from DBHDD has been saying, hey, Mr. Lowe is competent. Was there something that the court system received from you in 2019 or 2020 that should have triggered the very conversation we're having now? Or was there something different about what we received in 2021?
There was nothing different. I evaluated Mr. Lowe just as Drs. Chan and Dr. Shao did, and submitted an evaluation to the court opining that he was competent in both 2019 and 2020.
Well, I don't want you to think we ignored yours or didn't value them the same way. I don't know why. It may have been Ms. Love wasn't involved. I also know, unfortunately for Mr. Lowe, or maybe fortunately, the docket that has his case in it bounced around from a couple judges and only in the middle of COVID landed squarely on my desk, where it will stay. And I will maintain this case until it is whatever resolved means for Mr. Lowe. So it may well have been, Dr. DeRoe, that your report arrived and there either wasn't focus on it or COVID meant that there wasn't a whole lot folks were going to do with it. But I appreciate the work you did as well. Procedurally, and any one of the doctors who knows the answer can answer this. If Dr. Norman is going to be spending some time with Mr. Lowe, would that occur where Mr. Lowe is now, i.e. Georgia Regional, or would that mean that we have to bring Mr. Lowe to the county jail and risk disrupting whatever stable environment he's in?
Oh, no. Dr. Norman's welcome to come 24 hours a day, 4 a.m. if he wants to. And we can even do video evals if he's more comfortable with that.
Okay. Well, as long as he's allowed there, I'm going to require that. We are going to move Mr. Lowe only as a last resort if we're going to be meeting him here in court. Otherwise, it seems like he ought to stay where he is, given now 3 years running the finding that he's achieved some stability and some competency. So if I get him, meaning Dr. Norman, the order that allows him to evaluate Mr. Lowe, he can go to Georgia Regional. Do you foresee, any of the doctors, any issue getting your records to Dr. Norman if that's part of the order I sign? Are there HIPAA hoops we need to jump through, or given the nature of Dr. Norman's examination, that's just standard course that he'll get the file that says Lowe and he can look at all that stuff?
Yeah, with your order, our medical records department will provide all of his records to Dr. Norman.
Okay. So Ms. Love, I think we've got a plan. I may encourage Dr. Norman to move a little faster, but he needs time to review the file, get with Mr. Lowe, and then most importantly, generate that report, whatever his conclusion is. And then that seems like it would crystallize the situation. If someone who in the past had said not competent is now saying, I agree with these other doctors, Ms. Shubo is accepting what that would mean, which would be it's time then to move forward, focusing on the merits of the case. If Dr. Norman disagrees, then it sounds like we are at a situation that you and I have dealt with before, where we've got two respected experts or a series of experts on one side and one respected expert on the other who have contrary views, and someone has to resolve it. And unfortunately, the statute says it's the non-expert judge who resolves that. And that's what we would pivot to.
Right. Your Honor, I, of course, would welcome Dr. Norman's and any expert that the defendant feels needs to evaluate him. The only issue or change I would ask in that series of or sequence of events is that the court, since the court will likely be the one hearing the trial because the state does not demand a jury trial, and it seems that the defendant does not either, I would ask that the court set a date for trial.
This would be the competency trial.
Correct.
Not, okay.
Correct. And I understand that Dr. Norman probably is very backed up. Having worked with him, I do know that he can, within backed up situations, do evaluations pursuant to a court order, whatever that order may be. So I would ask that the court set at this time a trial date, a competency trial date pursuant to the guidelines set forth in the statute, and that the court direct that Dr. Norman conduct this evaluation, especially given that the department is giving him access whenever and however he needs it to the defendant to evaluate him, that the Dr. Norman conduct his evaluation within an amount of time within those 45 days that would allow us to then actually go forward. If they choose to not persist or proceed with the not competent to stand trial plea, then we just call off the trial. But at this time, we would have a set trial date, and it would push things along given the previous findings, because it's not the case that even DBHDD did not at some point find him not competent.
So I hear you on that. The one wrinkle to that is it's easy for me to set a date for a bench trial because I don't need jurors. And so I just need to find time on my calendar. Getting jurors is the complicated part. And I have only certain days that I can get jurors. And the defense hasn't committed one way or the other yet to bench versus jury competency trial. Ms. Shubo has hinted, but not committed. And that's how I heard it. And she's reinforced that. So I think she needs time to talk with her client, and maybe she wants to talk to Dr. Norman. I don't know. Either side can demand the jury piece. So I may still do what you're saying, but the other reason that we might have to cancel that date would be if the defense says, no, we actually want a jury to weigh in on competency. And then I'd need to get a different day.
And that would fall well within the guidelines of the statute, because the jury trial doesn't have to take place until within 6 months of the evaluation. So that would not even be a wrinkle, considering the fact that we would still have an additional, I can't do my math on the fly like this, 4.5 months to complete this portion of it. But just so that it is moved along, because given the way that things tend to progress, I have a whole spreadsheet of cases like this where I guess due to sometimes the prosecutor's lack of awareness of how things should flow, the cases just literally have sat for years. And the families need closure, the defendants need closure, and I would like to actually ensure that that happens and the case moves along.
Sure. No, I appreciate that. All consistent with due process. We want to take care of that. Ms. Shubo, anything you want to add in terms of the process? I think getting the obvious next step is getting Dr. Norman in front of the records
Yeah.
and then in front of Mr. Lowe.
And that is one of the main reasons he asked for the amount of time, because he has the records up to 2016, I believe, but that's 5 years of medical records and psychiatric records, and he wants to review them before he interviews.
Yep.
And so when we're talking about 45 to 60 days, given the fact that he told me he's testified in 4 hearings over the past, because they're bench staffed mostly, 4 hearings in the past 3 weeks, he said that was optimistic, was 45 to 60. And I said, I didn't think the court was going to give him much more than that, but I would ask.
Okay. The order doesn't say anything about how long.
No, the order was just a contact. And
Okay.
then contact and records.
Yeah.
You would then schedule when it has to be back for a new status or whatever.
Got it. Okay.
Yeah.
Well, I think I've got all that. Do any of the DBHDD doctors need anything more from you? You've done your work and we appreciate it, and you're going to continue to do your work. I guess you would simply need to know if there's going to be a trial on the question of competency. When is that? Because I suspect Ms. Love would be calling several, if not all of you, for that. But that's just getting that onto your calendar. I'm curious, how often do you get hailed into court to testify in matters like this? Is this once a week or once a month? You look forward to it? It's a special event?
It just depends. Not a lot of contested cases, but so contested cases, not as often.
Okay. All right. Well, we'll see what happens, and we'll certainly keep the 4 of you in the loop. Dr. Duro, do you need anything else from us, or you've shared your role in this and you're ready to get back to work?
I don't have anything else. Thank you.
All right. Dr. Chan, anything else?
No, thank you, sir.
Dr. Shao?
No, thank you.
Dr. Subramani, are you done with your rotation at DBHDD? Or are you still there?
I finished the 4-month rotation, but I did accept a position to be an inpatient psychologist starting in September.
Well, congratulations.
Thank you very much.
Look at that. It all worked out. Well, excellent. Mr. Lowe, is there anything you want to share at this point, or you're just taking all this in? I don't know if there's actually audio at Mr. Lowe's end.
There should be someone, there he is. Can you unmute him?
Hey, Mr. Lowe, anything
Okay.
you want to add, or are you good for right now?
I'm good for right now.
Okay, sir. Well, you take care of yourself. I think another doctor's going to come talk to you soon, and you stay safe, okay?
Okay.
All right. Well, thank you, whoever is operating in the background there, getting Mr. Lowe to the webcam and the microphone. Ms. Love, anything else from the state? I will, let me explain what I'm going to do, and then you can tell me if there's anything else. I will enter today this order that gives Dr. Norman access, because we got to get that before anything can happen. Then I'm going to get with my trusty partner, Ms. Nelson, to look at our calendar, and I'll probably make some dates clear as to when we'll be reconvening, when we need to try to get something from Dr. Norman. And I'll expect him to make his best efforts to meet those deadlines. Life is life. If something comes up and he can't, I trust we'll hear from defense counsel as to what happened and why that won't work. But I share Ms. Love's concern that we don't want things to expand too far. And I didn't get the sense that the defense was saying that. They're dealing with the expert that they have, and he's busy, as we all are. So I do think it's important that we press this forward. I don't know why people didn't grab a hold of Dr. Duro's earlier orders or findings to try to do this a year ago or 2 years ago. But certainly I would think it would be something that Dr. Norman takes into consideration, the extent of time that folks at Georgia Regional have been saying, hey, Mr. Lowe is available. So I think we'll go from there. Anything else, Ms. Love?
No, Your Honor. Thank you. That addressed everything that I had concerns about.
Ms. Shubo, it's great to see you physically in court. Glad you could make
This is
it.
actually the first time I've been in court since February 2020.
How's it feel?
I had to put on a suit, but besides that, it was fine.
All right, join the club. As I said, I was not wearing a tie 20 minutes ago, and they're like, oh, I'm in court. Anything else from the defense?
I don't think we got some of the reports, the 2-year ago report and maybe the 3-year ago report. I think Ms. Love said that she has them, but not only has Mr. Lowe gone through multiple judges, he's gone through multiple attorneys. So that may be at least the defense understanding. So we're more than happy to take everything and give that to Dr. Norman.
Great, please do. So Ms. Love, if you can get copies to Ms. Shubo, she'll get that to Dr. Norman. But I assume in the files that he would find when he got out to Georgia Regional would be all of Dr. DeRosa reports and the evidence behind it, et cetera, et cetera. So
I don't know if they would be in the medical records or in a different file, but as long as we have them, it doesn't matter.
yeah. Okay, good. Thank you everyone for joining us. Have a great day. We will be in touch, no doubt.
Thank you very much, Your Honor.
All right, bye-bye.